Good morning, everyone. I hope that everyone and their loved ones are safe and well. Thank you for joining us for our morning virtual workshop series. We have with us attorney Kimra Major Morris, and she is going to present 5 tips to protect your virtual business. Now, during this COVID-19 pandemic, we are seeing an increase in virtual sales and goods, and this is the perfect time to make sure that your assets, your trademarks, everything is protected while you're operating online. And Attorney Major Morris is the one to help us with that. She has been featured not only locally, but also nationally. She is an expert in this field, and since 2015, she has been recognized as one of America's super lawyers, which is a high level of distinction. So it's an honor and privilege for her to join us this morning. We are in for some high-level information, and without further ado, I will turn it over to Kimra. If during her presentation, if you have any questions, please make sure that you post those questions because we will have time for a Q&A at the end. All right, Kimra, thank you for joining us.
Thank you for having me. Good morning, everyone, and thank you all for attending. It's my pleasure, and thank you to the Chamber for having me and allowing me to share this important information. I am going to do a brief introduction. As Tanisha mentioned, I have been rated by super lawyers. I've been practicing for 11 years, and I am an honored Eagle Award winner for 2019. I am the host of a show called Legal Connections that's done in conjunction with FAMU Law. I'm a graduate of FAMU Law. This is done in conjunction with FAMU Law and Orange TV. And I'm a nationally published author on the subject of trademarks. I have a recent article, it came out last year, on co-branding in the American Bar Association Journal. I'm also the former chair of the Florida Bar IP Committee. Proud to say that I'm the first person who looks like me who's able to hold that position. I am the IP advisor for the Trayvon Martin Foundation and have been since its inception in 2012. I had the honor of teaching a course with Goldman Sachs, the 10,000 Small Businesses program. Recently became a national speaker and joined the Microsoft community and doing workshops that have been broadcast throughout the country and actually internationally to their small business owners. And before COVID-19, I was scheduled to speak and do a couple of seminars on the Tom Joyner Fantastic Voyage. Hopefully that'll be coming again soon. So, as you might be able to tell, this is a topic that I am very fond of and have spent a great amount of time studying and teaching. And I just want to talk about where we are now with virtual. So many businesses have been thrust into the virtual space. And there are a few things that everyone should know, everyone who's running a business should know about intellectual property. So we're just going to do an overview of the basics. And I'm going to give you 5 tips about what you can do as a business owner to put yourself in a stronger position as a business owner with virtual practices. So the first thing is to identify your intellectual property. And that's a big thing. I put it first because there are so many of us who don't have a basic knowledge, and it's not common knowledge. I didn't even know until I studied it in school, so it's not a criticism. It's just something that we don't talk about enough. And so if you don't know that you have it, then you can't protect it. And so I'm going to spend a little bit of time just going over what intellectual property consists of. And so that way you can be on the lookout for what you have as a business owner. So there are 4 kinds of intellectual property: copyrights, trademarks, trade secrets, and patents. So spend a little bit of time on the copyright topic first. As a business owner, you probably have a website or even a social media page where you have drafted the language on that page. You may have a blog, you may have newsletters, marketing materials, design of business cards, software apps, those are things that consist of original works of authorship. So the question is, do you as a business owner own these things? Did you design your own website? Did you design your graphics? If you hired a contractor or some company, then you may want to look at the language in those agreements to make sure you are the owner of your copyright. A lot of times, it's assumed that when you make a purchase, you're the owner of the thing. This is typically how this goes, right? You go to the store, you buy whatever, it's yours. In the intellectual property space, particularly with copyrights, when you buy a photograph, you ordered a photo shoot, check to see that the language in the contract says that you are now the owner of the photos, because if not, by default under copyright law, you are the owner of the copy of the photos. So the same is true with a website. If there's no ownership transferred in writing, then you are the owner of the design. You're not the owner of the content. You're not the owner of the images that may have been uploaded to enhance the site. So you want to double check that. What about the blogs? Did you write your own blog? Or maybe you have a contractor who did it, your assistant, a college student, whomever. You want to make sure that you have in your independent contractor agreements language that says that it is a work for hire and that the ownership is being assigned. Anytime you see the word assignment, it's a transfer of ownership. So make sure that the contractors you're hiring are signing off and relinquishing their ownership rights in the things that they're creating for you. Software apps. You hired somebody to do the app. What does the contract say with the developer? A lot of times, also, um, we just don't know where people got things from. And so, what do I mean by that? You have a student and they're doing your social media and they are designing your Canva, your marketing materials on Canva, for example. Where did they get the elements? Did they pull things from the internet? You want to make sure you want to confirm what it is you own and what it is you don't own that is being published on behalf of your company. And we'll get into the reasons why that's really important. But this first part is just so you can recognize some of the copyrights that may be incorporated into your business practices. Every business has a trademark. So you might not think you have one because you haven't registered it with the government, but every business has a trademark because the name of your business is being used in association with certain goods and services, which is the function of a trademark. And so whether you register it is something more along the lines of something that we think about when we think of business strategy and the strength of our brands, what rights we want to have with that trademark. But trademarks are brand identifiers, can be names, logos, slogans, symbols, sounds, and smells. There's one of the telephone stores or mobile stores. Can't remember if it's Verizon, but they have trademarked the smell. Sounds, we have the NBC sound when their shows come on. That's a trademark. Even people's voices. You think of Morgan Freeman's voice. If someone else came on and did a commercial and intentionally sounded just like him, he could potentially have a trademark infringement suit or unfair competition because he has a trademarked voice. Um, these are things that are famous in our society, and sometimes they don't have to be registered for us to recognize them as trademarks. So common law trademarks, that's what we have before we register them with the government, are limited to the geographic area where your business is registered. So if you start a mom and pop store, and of course you did the search on Sunbiz, and Sunbiz only tells you the name of the license, the name that's allowed in the state of Florida that you can do business under, but they don't hold any responsibility for liability in case your infringing on someone else's rights. So let me say that another way. When you do a search to start your Florida business, all you're required to do is come up with a name that's not already taken on the list of previously registered Florida businesses. There is language on the Division of Corporations for each state that may not be as plain as it should be, but it tells you that they are not responsible if you choose a name that happens to infringe on someone else's name in another state, or if it happens to infringe on a federal trademark even. So that's one of the reasons why you want to make sure you're doing a trademark search before you name your business, because just because you're allowed to name it and conduct business in the state of Florida doesn't mean that it's not infringing on someone else's rights. But every business has a trademark. You just have a common law trademark that's limited to your geographic area unless and until you decide to apply for federal protection. Trade secrets, just what it sounds like. These are the things that your business relies on to set it apart from other businesses. Many of us know how to fry chicken, but we don't know KFC's process. We don't know exactly how they do what they do, but that is their trade secret, and they've managed to keep it a secret all these years. Coca-Cola has a trade secret. There are numerous companies. Your mailing list qualifies or could potentially qualifies as a trade secret if that's giving you a competitive edge, and if it has not been disclosed. Are you quietly working on something? You know, I told you that I had plans to speak on this cruise, and that was not common knowledge until it was publicly announced, right? But there could be some deal that you're working on in the background, and you have somebody working with you, and this deal is going to set your business apart in some way, or be groundbreaking. And if the people in your inner circle disclose that before it's time and take away the advantage that you had, then that's a potential violation of a trade secret. So these are things that are kept secret, and it's your responsibility as a business owner, if you have a trade secret, to make sure that you have some processes in place. So if you have the formula, the secret formula on your one computer, you want to make sure you properly label that so that everybody can see that this is where the secrets are held, so that no one will ever be able to claim that they didn't know that your trade secret was a trade secret. So you want to identify those. The patents are the inventions. This word gets confused often, or this area gets confused with trademarks. Some people misuse it by saying if you have an expression that they think is catchy. Yeah, I've heard people say you should patent that. Well, the reason that's wrong is because patents are inventions, inventions of things that are functional. So here are the three kinds of patents. Processes, we talked about, trade secrets. And so some trade secrets are eligible for patent protection and others are not. So I'll go back to the chicken, the KFC formula process, where all ingredients are they're readily available. And if someone reverse engineers that recipe, then that's a way that's not breaking the law. We can say that KFC didn't do a good job of keeping their secret. But when someone has a patent, they actually have to apply with the United States Patent and Trademark Office. It's a long, expensive process. But before they get to the final part of that application, the trademark office, the patent office, told them that what they have invented is new. It's it and it requires, and it's going to be there. It's going to last exclusive right to their invention and be able to charge royalties and license this patent for 20 years. After 20 years, it goes into the public domain. But it had to be, number one, determined or deemed patentable in the first place. And then it went through this process where you have to include diagrams and all these things to show how it works, and that remains sealed for 20 years. And with that power, then you're able to conduct business and go out and have people pay you to use your invention. So processes, new machines, chemicals, a lot of software no longer qualifies for patent protection because a lot of the functions have already been done before. A lot of times people ask about a new business idea. You know, you have to ask yourself, what's the difference between Lyft and Uber? It's the same business model because in our country, we promote fair competition. So it's hard to lock in a business model. You know, you can't lock in a business model. You can only lock in a patent. So people can copy the kind of business that you have, and then you're going to be competitive based on your brand, which is the trademark. So you want to identify the patents in your company. And I was saying that software applications a lot of times are not eligible for patents because the functions of the app have already been done. The only thing that's going to be different a lot of times is the graphics, the trademark, you know, the brand name, and you know the particular products or services that are being sold through the app. But the functions are primarily the same. You're going to order here, you're going to click here to, you know, to display. You know, those functions have already been done, and it's no longer considered an invention, which is the reason why, like, if there's some unique features, that's the reason why a lot of times people will send the code to the software app to the copyright office. Because remember, a copyright is a unique expression of authorship. It's an original work of authorship. And so if your software app is something different, it qualifies for, because that's something artistic now. It's not considered an invention, which is why it would not go under the patent category. Design patents, sometimes software apps fall under this category. And the way you can qualify for a design patent is by having some functional feature that's different. It can't just be the look of it. It has to be something that's added on to it that makes it function differently. So a unique appearance to a pre-existing object. But that appearance cannot just be on the face of it. It has to serve some sort of a function. Plant products, new and distinct plant hybrids qualify for patents. So you have these people in the lab doing different things with plants to create different fragrances, and those qualify for patents. So remember, step one was to identify the intellectual property that you have. And now that you have some idea of what intellectual property is, hopefully you'll go back, you know, through your business processes and services and figure out what it is that you might have that makes your business qualify for these protections. Now, the consequences of not registering your intellectual property: copyrights are registered with the Copyright Office, which is located in the Library of Congress in DC. The Trademark Office is in Alexandria, Virginia. It's USPTO, stands for United States Patent and Trademark Office. The website is uspto.gov, and the Copyright Office is copyright.gov. So you can spend some time. I'm sorry, something is suddenly in my throat. Excuse me. You can spend some time on either one of those websites, excuse me, and learn about copyrights, trademarks, and patents. Trade secrets, again, are not something that you register. You're just going to keep them a secret. So the consequences of not registering your intellectual property. In the case of a trademark, your brand identity cannot be protected online. Amazon has something, if you are someone who sells products, Amazon has something called the brand registry, and you are not even allowed to sign up for the brand registry, which is a program. You're not allowed to sign up without a registered federal trademark. The brand registry is a program that Amazon has that helps you to track on their site unauthorized products, unauthorized uses of your brand, infringing uses of your brand. And they pull those things from their site. If you have registered through with their program. If you don't have a federal trademark registered, then you cannot even sign up. So then what happens? It really affects your bottom line because you're not able to enforce your rights in that online space. Even with social media, other platforms, Instagram, Facebook, Twitter, you have the copycat out there that's using a logo or a name similar to yours and selling similar products or services. They won't even pull the copycat's page down unless you show them your federal trademark registration, not your application, your registration. And the registration process takes quite a bit of time, and we'll talk a little bit more about that, but it's worth it because now that you're doing this business online, you want to be able to police what's happening with your brand identity. So of course that that contributes to diminished brand strength. If other people are out here using something similar, then your consumers aren't really sure. They don't have the confidence they should have when they approach a social media page and they see a similar emoji or avatar on a page. They're not sure if it's yours or not because the difference in it is going to be too slight, and you don't have the rights that you should have to have it pulled. Here is a list of distinctions between state trademarks and federal trademarks. So many people aren't even aware that they can get a state trademark. Sometimes when they do get a state trademark, they think that they have the same rights or close enough rights to the federal mark. So the state of Florida is what I'm referring to on this slide only, because every state's guidelines are different and the coverages are different. But in the state of Florida, when you apply for a trademark, the filing fee is about $87. And you have to have, one thing that's not on this screen is you have to already be using the trademark in the state of Florida to get a trademark, to apply. I'll give you an example. You're a startup company and you already know the name and the logo that you'd like to use, but you're not going to be ready because your website, all the stuff in the background is being worked on, but you just want to lock it in. Well, that's great, but the state of Florida won't let you lock it in until you can show them at least 3 kinds of marketing materials in your application. And of course, you don't have those yet because you're up and coming. You can do that on the federal side. So on this screen or in your notes, you might want to note for this screen, on the federal side, you can file an application or you can reserve a name. On the state side, you cannot reserve a name. You have to already be using it. Of course, your state trademark is going to be limited. It's going to limit your exclusive right to your business name or logo in the state of Florida, where on the federal side, you have exclusive rights that you can exercise throughout the country, which is why you can pull these things from the social media pages because you're nationwide. And so it doesn't matter that, a social media user is located somewhere else. As long as you can present your federal trademark certificate, upload it on one of those platforms, then they will take action to pull down the infringing page that's misleading people. The state trademark is going to expire in 5 years. If you'd like to renew it, you have to pay a fee and show them that you are still using your trademark, and they will renew it, and it's good for another 5 years. On the federal side, and of course these things last forever if you're still using them and you still maintain them with these fees, and you have to check in with the granting of the authority or entity. So on the federal side, you have maintenance requirements that are every 5 years. So you're going to renew it every 10 years though. So that might sound tricky, but what it means is if you register your trademark in 2020, when 2025 comes, I'm sorry, when 2025 comes, and you have to reach out to the trademark office and file an affidavit letting them know you're still using your trademark, and you have to send them the proof, upload the proof, and then there's a filing fee of $125. So that's not a lot. The first filing fee is $225 on the federal side. Remember, I told you it's $87.50 for the state of Florida. When you renew on the federal, when you file your affidavit 5 years in, then you're good for another 5 years. So the next time you have to file it is between the 9th and the 10th year. But you can continue to do this. And as long as you're using your trademark as you said you would, and that's important, as you said you would. I have so many creative clients that love to change the look of their logo. Don't do that if you have a federal trademark or any trademark, because the whole point is that you are asking for the exclusive right to use this thing, exclusive right to use a particular thing. So if you go making revisions to it, then you're diminishing your own rights. So this screen is really important, because, oh, and then the circled R. The circled R stands for federally registered mark. And a lot of people think it looks good in their marketing materials, and it does, but you have to actually go through the process of applying to the USPTO for federal protection before you have the right to use this R. If you don't have a federal trademark, you are allowed to use the TM symbol anytime. You can actually use that for your pending trademark. You can use it in advance, but and some companies, for style purposes, they just keep the TM on their marketing materials even after they have a registered trademark. It's optional if you have a registered trademark. But if you don't have a registered trademark, it's not optional, and it's actually against the law to use the circled R if you don't have one. All right, so don't miss out on money really by not filing a copyright registration. Um, you can qualify for statutory damages if you have already submitted and obtained a copyright registration before someone copies your content, your photos, whatever it is. So if you have a copyright registration in place first, then you can qualify for what's known as statutory damages. And statutory damages is the same thing as a fine that will be assessed against you after a court has heard all the facts, and they determine if it's, you know, how you did it, if you were aware that you were copying. There are lots of factors that go into these rulings that determine the amount of money that the copyright owner is eligible for. So you want to not delay that. I usually advise my creative clients or people creating content to put yourself on a quarterly schedule for registering your copyright. So filing fee to register the copyright is just $55 for most things. If you have audio visual stuff, then sometimes those filing fees are $85. It just really depends on the size and what it is you're submitting for protection. But it's so worth it. $55 or $85 is your investment, and maybe legal service fees, which are not going to break the bank. And then you get these things protected, and especially before you send your content to a web developer. I had one of the worst stories I heard was a woman who had hired a web person, and she gave her wireframe. She gave everything to this web developer. They had no agreement in place. It was somebody that was introduced to her by a mutual friend. Her website never got done with this idea that was pretty creative. And the next thing she knew, several months down, was that somebody had done exactly what she was going to do. It was a business idea, much like what we were talking about with Uber and Lyft. And then so she could still do it, but now she could no longer claim that she was the first to do it. So the reason I mention that is because one thing that could have put her in a better position would have been if she had submitted a copyright application to protect her work, the way she had it laid out, because the copycats did something that was almost identical, and she had no legal recourse really when after she realized her idea and many of the things that she had drafted were stolen. So you want to register it early to be eligible for statutory damages. if you register your copyright after you discover that someone has copied it, you will still have a registration and still be able to take them to court even after, but you're only going to be limited to the actual damages, like how much did you actually lose. So a lot of times that's hard to prove. And you're going to be limited to the infringer's profits, if any. So they could have just copied your stuff and not done it, not had the right marketing, and maybe they didn't make any money. So you're just at a complete loss because they had no profits that you could collect after your court proceeding. No attorney's fees. You're not going to get reimbursed for those if you don't have a copyright before the infringement. And then one of the other benefits of having a copyright registration is that, let's say it's books, and your books, this was happening a lot in the educational system where textbooks were being imported. And there was a big Supreme Court case about that, where some of these international um, manufacturers or providers were bringing things into the country. But when you have a registered copyright, then just as with on the trademark side for infringing goods that are coming into the country, you can actually have U.S. Customs and Border Patrol to stop the unauthorized items from being imported. So those are some pretty big benefits for registering your intellectual property. So number one, you want to identify it. And number two, you want to register it. Of course, you don't register a trade secret. You're going to have to keep that secret. And all your people around you have to keep it secret. And then the patent process is lengthy. I am not a patent attorney, by the way. I do all the other areas of intellectual property law, but I can recommend some pretty incredible patent attorneys. Now, the third tip is to define what work product means in for any virtual assistance that you might be getting. So, let's say virtual assistants are big right now, especially with all the delegating that must go on. You're not going into the office space, right? And for the people who used to work with you, then you need to make sure that you're identifying those things that will belong to you at the end of their service and won't. So their duties have changed. I'll just give you a hypothetical. You used to have someone that was working with you in the office. Now everything's virtual. You can't afford to pay that person a full-time salary. So you're looking for a virtual assistant. They're also referred to as VAs for short, a VA. So when you tell your virtual assistant what you need them for, you might say, well, I'd like you to do my social media post for me. I need some better ideas. I want my stuff to look competitive. Also, can you help me with my newsletter? I had started writing it, but I need you to finish it and make it, word it so that it appeals to this age group. Okay, so those are two things you ask them for. You ask them for better graphics, and you also ask them to help you with drafting your newsletter. But you already started it, remember? So now, in your independent contractor agreement, it says nothing. It's silent about who owns the content after the virtual assistant finishes. And then you see that this person now works for your competitor, also because he or she is a virtual assistant, and he or she is not exclusive to you, but they're doing something almost identical for your biggest competitor. So your agreement with this person does not give any terms and conditions, doesn't say what they're allowed to do with the content, and we don't even know who the author is based on the wording that's not in your agreement. So that's an issue. So this is why you want to be as detailed as possible in your agreements with your virtual assistants, because if you don't identify who's going to own what they're creating, then it could be a big problem for your business down the line. So some examples are the proposals. You're submitting this proposal for this thing. Again, that same proposal could be revamped for your biggest competitor. The research that they're doing. They pulled out all these statistics, and that kind of stuff means something when you're trying to impress investors and your projections. And if they did all that for you, but you'd never said that it was going to be yours and that they did not have the right to duplicate it, then that's an issue. So define clearly what the work product means for your virtual assistants. Warranties and representations. Wow, this one here gets overlooked in contracts really frequently. And if your contractor's work is violating someone else's intellectual property, if it's infringing on someone else's property, I'll go back to the web designer. Your graphics look great. You're happy with it. And then a few months down the line, this just literally just happened to one of my clients a couple months ago, where the person who did their website used a picture on the blog part of their website. And it wasn't even something that was, I don't know, wasn't it wasn't anything remarkable. It just as simple as a piece of paper, and this is not what it was, but it was as simple as a piece of paper with a pen lying on the piece of paper. It was a picture of something that basic. And the designer had used it on 3 different titles on the website, at least 3. So it was like different positions. So let's say there's a piece of paper and there's a pen that's in a horizontal position. Then on the next picture, the pen was in a vertical position. And then on the final one, the picture was diagonal, right? So it was something basic like that. So my client got a cease and desist notice demanding $3,800 because the images had been downloaded from the internet, and they, of course, belong to someone else. And so, but they were registered, those pictures were registered with the Copyright Office. And remember, we talked about the statutory damages. So that particular owner was potentially eligible for $750 per infringing picture per use. So I told you that it was used at least 3 times. So by law, that person was going to qualify for damages of at least $2,100. So the demand letter was $3,800. We were able to negotiate it down. But going back to these warranties and representations, the person responsible was the person who pulled the pictures from the internet without knowing that just because it's on the internet doesn't mean it's in the public domain. And just so everyone knows, it takes the lifetime of the author plus 70 years for a copyright to go into the public domain. That means if you write a newsletter today, and you pass away next week, then the copyright does not go into the public domain for another 70 years. So when we see things on the internet and we just don't see a copyright symbol, you might see that wording that says this image may be subject to copyright protection, then that is something to be taken seriously, because these are strict liability laws where, you know, it's really up to the author to decide if they want to take you to court, but you're not going to win if you didn't have permission to use it. So get the warranties and representations as you work virtually from anyone providing content for you, because they may be copying or infringing on someone else's rights, and you want to be able to at least sue them, you know, and make them responsible for this. But if you don't have any language saying that they are assuring you that they're not infringing on someone else's rights, then your business is going to be on the hook for the settlement fees to make it go away. Require a non-disclosure agreement, because that way, if someone does infringe on your copyright or somehow engage in unfair competition with the logo that they gave you, then you have 2 causes of action in your lawsuit at least. You would have the breach of contract because they have breached the NDA, the non-disclosure agreement, where they weren't supposed to do XYZ. And then you would have the trademark component or the copyright infringement component. So you want to do that because you're just adding another layer of protection for you and your business. I'm going to open it up for questions now. It's 10:40, and
Hello, hopefully everyone can see me and hear me. Kimra, are you still there?
I am.
Okay,
And
well,
I see that Eugenia said she could not hear. I don't know when that was put up, but was it a while ago?
I could I could hear you, but I think that there may have been a few that could not hear you.
Oh,
Um,
wow.
okay, but are there any questions? I guess you covered everything so thoroughly, Kimra.
Ah, that's
You did
good.
absolutely. Thank you again for joining us. I do have a question. Anything that our listeners and this is recorded, so for even those who watch afterwards, any red flags or anything that they should be on the lookout for just to make sure that they protect themselves?
I'm sorry, I'm Tanisha. I see some questions, and you were asking about the red flags for.
Yes, anything red flags or anything that businesses should kind of be on the lookout for so that they can protect themselves.
Oh, certainly. So one of the things that I like to recommend business owners do is start another email, um, because you may get a lot of these, and sign up for Google alerts, because that way you can catch some of the ways your company's name is being mentioned online. So it'll help you track the uses or similar uses to whatever you put into the Google alerts. But you don't want to put it in your main email because the alerts, could cause you to get, depending on what your brand name is, it could clog up your regular email. So I just recommend you set up another email account just for the purpose of tracking potentially infringing uses of your business name. And
Great,
every once in a while, do a Google image search for your logo to see if it pops up anywhere that you haven't authorized.
absolutely great advice. And then you did receive some other questions.
Mm-hmm. Thank you, Carol. Great information. And taglines. So taglines are, I put them in the same category with slogans, but those are potential trademarks. Oh, this is something I want to point out. I get a lot of questions about this. Nike is my favorite example to cite. So, you know how you see a t shirt that says Nike sometimes, and then sometimes it'll say just do it, and sometimes it'll just have the swoosh sign. Those are all separate trademarks. So, business owners should know that if you have different elements to your brand identity, you have the option of protecting them separately and being able to use them separately. Or if you file a joint application, those elements are going to be married. So you will be required for the strongest protection to use them all together. So, in other words, if Nike didn't have separate applications, every t shirt we saw would have Nike, the swoosh sign, and just do it on it. But because they invested in separate protections, we see them separately. So that was Al's question. A template for those agreements, that's a service I provide, and I can do templates, but I'd like to do templates after I learn more about your business operations. So, one reason why most attorneys don't advocate for the general templates you can find online is because they don't take into consideration the things that make your business run the way it runs. They also, a lot of times, don't take into consideration the state that you're in and new laws that have been passed since the template was created. So, if you're not citing a statute that talks about the latest subsection of the trade secret law, then you could be harming your client. So, I'd be happy to discuss a template that will work for your business once I learn more about it if you're interested, Monda. Also, if we hire someone from Fiverr, should we send them an agreement prior to working with them? What I've noticed is that the contractors on Fire and Upwork, they have a basic agreement that acknowledges that they are work for hire. But I do also recommend that you look for language in your agreements that says, and if you don't see it automatically, ask them to assign. That's the key word. Ask them to assign the work that they're creating for you. That way, the ownership of it will be transferred. because a lot of times people pay for this work, and if you're not sure that you even own the logo, then how can you then go and try to get a registered trademark if you haven't even cleared up the title to the work? Are taglines copyrightable? Those fall under the trademark category. For recipes, does that fall under a patent or a copyright? Well, it depends, because sometimes recipes fall under trade secrets, because remember we talked about Coca-Cola, and the only way they're more likely under trade secrets if there's a process or a formula that's not public, and then you're able to keep it secret with the people working with you, then it falls under trade secrets, and then you would need a strong non-disclosure agreement. But you would not do a copyright registration for something that's a trade secret, because copyright registrations are public. So that kind of defeats the purpose. So for the people who are doing apps and whatnot, we don't recommend that. Yes, Jean said, I love using Google Alerts. You can even put in keywords for your competition so you can track what they're doing too. That's absolutely right. And, we have to be, that's what this is all about, is being strategic, making sure you're protected, because good business strategy, and talking about that, investors, many of us watch Shark Tank, and that's often one of the first things that the investors want to know, is this protected? Because they want to know. It's their insurance. Why should I throw money behind this thing and it's not even protected? You haven't even invested in yourself. Should all business idea documents have attorney review before hiring a vendor, like a content editor? I would recommend that, just for the reason, some of the reasons stated already, is you just want to make sure that your content is your content. And the services are creative services. Those are copyrightable things that they're delivering to you. So the main thing, even if you don't have the budget to hire an attorney, at the very least, make sure that the content you're paying for is yours after the services are rendered. So the word of the day is assignment. You want to make sure you have an assignment clause in those contracts for the creative services you're paying for. Any more questions? Those are some good ones. Okay, well, this is my contact information on the screen, and I provide 15-minute complimentary consultations. They are general. The consultations, for example, this presentation was general information. So if you have a question without me going into a lot of facts about your particular business or scenario, then that usually qualifies as a general consultation. I do provide those just to steer you in the right direction. But I'd be happy to speak with you, and I appreciate you all tuning in. Tanisha, thank you, and the Chamber again for allowing me to share.
No, thank you, Kimra, for joining us this morning. And I encourage everyone to please visit Kimra's website. It's up on the screen, www.majormorrislaw.com. As she said, she does provide complimentary 15-minute consultations. And it's almost something that this is something you can't afford not to invest in, because as Kimra said during her presentation, if you don't get it right, it can cost you a lot more later. She does have several packages that are available too, depending on what the needs are for your company. So again, I encourage you to reach out and just explore, what your needs may be, and if she will be able to assist you. So again, thank you, Kimra, for joining us. Thank everyone else for joining us for our virtual workshop series. We do have some additional ones coming up. The next one is this Thursday. We encourage everyone to join us for a town hall meeting with Senator Mark Rubio and State Representative Kimra Brown. This is important as we talk about the Paycheck Protection Program, PPP. As you all know and heard last week, the money was announced that it ran out, and many of our businesses did not benefit. So we need to make sure that you have all your documents together. It could be as early as today or tomorrow that the federal government funds this program again, and we want to just make sure that our businesses are prepared and ready to apply so that you're in line for the money when it's released. We have another virtual workshop coming up on the 23rd, and that is with Courtney McKenzel Newell. Build your network and increase sales. That's something that we all need to be working on constantly, but especially during this time. Then next week, we have a virtual workshop, Bootstrap Branding, 100 things you can do for $100 or less to revamp your brand. So please visit our website, www.blackcommerce.org. We want you to save the date for our first business conference, which will be August 21st, 2020. It's a full day business conference with the Empowerment Luncheon, one of our signature events, which is we're known for. We'll also have a Diversity Supplier Expo. So that's something you will not want to miss. We're gearing this to help our businesses come out of COVID-19 and everything that we've endured. So we're going to have some good tools to help those in attendance at our business conference. If you have any questions, you can reach us. Although we're working remotely, you can reach us at info@blackcommerce.org. Again, thank you for joining us. Stay safe and healthy, everyone, and have a good rest of the day.